Rome Statute of the International Criminal Court, Issues of Admissibility and Applicable Law. Article 17. Issues of Admissibility. 1. Having regard to paragraph 10 of the Preamble and Article 1, the Court shall determine that a case is inadmissible where a. The case is being investigated or prosecuted by a state which has jurisdiction over it, unless the state is unwilling or unable genuinely to carry out the investigation or prosecution. b. The case has been investigated by a state which has jurisdiction over it and the state has decided not to prosecute the person concerned, unless the decision resulted from the unwillingness or inability of the state genuinely to prosecute. c. The person concerned has already been tried for conduct which is the subject of the complaint, and a trial by the court is not permitted under Article 20, Paragraph 3. d. The case is not of sufficient gravity to justify further action by the court. 2. In order to determine unwillingness in a particular case, the court shall consider, having regard to the principles of due process recognized by international law, whether one or more of the following exist, as applicable. a. The proceedings were or are being undertaken or the national decision was made for the purpose of shielding the person concerned from criminal responsibility for crimes within the jurisdiction of the court referred to in Article 5. b. There has been an unjustified delay in the proceedings which in the circumstances is inconsistent with an intent to bring the person concerned to justice. c. The proceedings were not or are not being conducted independently or impartially, and they were or are being conducted in a manner which, in the circumstances, is inconsistent with an intent to bring the person concerned to justice. 3. In order to determine inability in a particular case, the court shall consider whether, due to a total or substantial collapse or unavailability of its national judicial system, the state is unable to obtain the accused or the necessary evidence and testimony or otherwise unable to carry out its proceedings. Article 18. Preliminary rulings regarding admissibility. 1. When a situation has been referred to the court pursuant to Article 13a, and the prosecutor has determined that there would be a reasonable basis to commence an investigation, or the prosecutor initiates an investigation pursuant to Articles 13c and 15, the prosecutor shall notify all states parties and those states which, taking into account the information available, would normally exercise jurisdiction over the crimes concerned. The prosecutor may notify such states on a confidential basis and, where the prosecutor believes it necessary to protect persons, prevent destruction of evidence or prevent the absconding of persons, may limit the scope of the information provided to states. 2. Within 1 month of receipt of that notification, a state may inform the court that it is investigating or has investigated its nationals or others within its jurisdiction with respect to criminal acts which may constitute crimes referred to in Article 5 and which relate to the information provided in the notification to states. At the request of that state, the prosecutor shall defer to the state's investigation of those persons unless the pretrial chamber, on the application of the prosecutor, decides to authorize the investigation. 3. The prosecutor's deferral to a state's investigation shall be open to review by the prosecutor 6 months after the date of deferral or at any time when there has been a significant change of circumstances based on the state's unwillingness or inability genuinely to carry out the investigation. 4. The state concerned or the prosecutor may appeal to the appeals chamber against a ruling of the pretrial chamber, in accordance with Article 82. The appeal may be heard on an expedited basis. 5. When the prosecutor has deferred an investigation in accordance with Paragraph 2, the prosecutor may request that the state concerned periodically inform the prosecutor of the progress of its investigations and any subsequent prosecutions. States parties shall respond to such requests without undue delay. 6. Pending a ruling by the pretrial chamber, or at any time when the prosecutor has deferred an investigation under this article, the prosecutor may, on an exceptional basis, seek authority from the pretrial chamber to pursue necessary investigative steps for the purpose of preserving evidence where there is a unique opportunity to obtain important evidence or there is a significant risk that such evidence may not be subsequently available. 7. A state which has challenged a ruling of the pretrial chamber under this article may challenge the admissibility of a case under Article 19 on the grounds of additional significant facts or significant change of circumstances. Article 19. Challenges to the jurisdiction of the court or the admissibility of a case. 1. The court shall satisfy itself that it has jurisdiction in any case brought before it. The court may, on its own motion, determine the admissibility of a case in accordance with Article 17. 2. Challenges to the admissibility of a case on the grounds referred to in Article 17 or challenges to the jurisdiction of the court may be made by a. An accused or a person for whom a warrant of arrest or a summons to appear has been issued under Article 58. b. A state which has jurisdiction over a case, on the ground that it is investigating or prosecuting the case or has investigated or prosecuted, or c. A state from which acceptance of jurisdiction is required under Article 12. 3. The prosecutor may seek a ruling from the court regarding a question of jurisdiction or admissibility. In proceedings with respect to jurisdiction or admissibility, those who have referred the situation under Article 13, as well as victims, may also submit observations to the court. 4. The admissibility of a case or the jurisdiction of the court may be challenged only once by any person or state referred to in paragraph 2. The challenge shall take place prior to or at the commencement of the trial. In exceptional circumstances, the court may grant leave for a challenge to be brought more than once or at a time later than the commencement of the trial. Challenges to the admissibility of a case, at the commencement of a trial, or subsequently with the leave of the court, may be based only on Article 17, paragraph 1, c. 5. A state referred to in paragraph 2, b, and c, shall make a challenge at the earliest opportunity. 6. Prior to the confirmation of the charges, challenges to the admissibility of a case or challenges to the jurisdiction of the court shall be referred to the pretrial chamber. After confirmation of the charges, they shall be referred to the trial chamber. Decisions with respect to jurisdiction or admissibility may be appealed to the appeals chamber in accordance with Article 82. 7. If a challenge is made by a state referred to in paragraph 2, b, or c, the prosecutor shall suspend the investigation until such time as the court makes a determination in accordance with Article 17. 8. Pending a ruling by the court, the prosecutor may seek authority from the court. A. To pursue necessary investigative steps of the kind referred to in Article 18, paragraph 6. B. To take a statement or testimony from a witness or complete the collection and examination of evidence which had begun prior to the making of the challenge, and c. In cooperation with the relevant states, to prevent the absconding of persons in respect of whom the prosecutor has already requested a warrant of arrest under Article 58. 9. The making of a challenge shall not affect the validity of any act performed by the prosecutor or any order or warrant issued by the court prior to the making of the challenge. 10. If the court has decided that a case is inadmissible under Article 17, the prosecutor may submit a request for a review of the decision when he or she is fully satisfied that new facts have arisen which negate the basis on which the case had previously been found inadmissible under Article 17. 11. If the prosecutor, having regard to the matters referred to in Article 17, defers an investigation, the prosecutor may request that the relevant state make available to the prosecutor information on the proceedings. That information shall, at the request of the state concerned, be confidential. If the prosecutor thereafter decides to proceed with an investigation, he or she shall notify the state to which deferral of the proceedings has taken place. Article 20. Ne bis in idem. 1. Except as provided in this statute, no person shall be tried before the court with respect to conduct which formed the basis of crimes for which the person has been convicted or acquitted by the court. 2. No person shall be tried by another court for a crime referred to in Article 5 for which that person has already been convicted or acquitted by the court. 3. No person who has been tried by another court for conduct also proscribed under Article 6, 7, 8 or 8 bis shall be tried by the court with respect to the same conduct unless the proceedings in the other court a. were for the purpose of shielding the person concerned from criminal responsibility for crimes within the jurisdiction of the court, or b. otherwise were not conducted independently or impartially in accordance with the norms of due process recognized by international law and were conducted in a manner which, in the circumstances, was inconsistent with an intent to bring the person concerned to justice. Article 21. Applicable law. 1. The court shall apply a. In the first place, this statute, elements of crimes and its rules of procedure and evidence. b. In the second place, where appropriate, applicable treaties and the principles and rules of international law, including the established principles of the international law of armed conflict. c. Failing that, general principles of law derived by the court from national laws of legal systems of the world including, as appropriate, the national laws of states that would normally exercise jurisdiction over the crime, provided that those principles are not inconsistent with this statute and with international law and internationally recognized norms and standards. 2. The court may apply principles and rules of law as interpreted in its previous decisions. 3. The application and interpretation of law pursuant to this article must be consistent with internationally recognized human rights and be without any adverse distinction founded on grounds such as gender as defined in Article 7, Paragraph 3, age, race, color, language, religion or belief, political or other opinion, national, ethnic or social origin, wealth, birth or other status.